The next case to come before the court is Jennifer L. Traven v. Trevor N. Traven. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. And if you do plan to reserve time for rebuttal, please let me know. I will keep track of time and I'll try to alert you to when you're running into that rebuttal time. The arguments are being recorded. When you present your arguments, please introduce yourselves, stay behind the podium, keep your voice up. You shouldn't use the names of children, minors, victims during your argument should that be relevant. You can refer to those individuals with initials or terms that are general, like the child. We have read your briefs and we are ready to proceed when you are. And I would just ask appellant, would you like to reserve time?
Yes, please.
Okay, how much time would you like to reserve?
I doubt I'll need the first 10, but 5 minutes.
5 minutes, very well. Then you may proceed when you are ready.
Okay. Good morning. May it please the court, my name is Attorney David Berta. I represent the appellant in this case, Trevor Traven. The matter before you, Your Honors, I believe is a very simple matter. There was a divorce that was filed. The divorce had proceeded to trial. Accordingly, the magistrate had issued a decision which was adopted by the court, the lower court, on June 27th, 2023. In the docket entry indicated it was sent by ordinary mail on June 30th of 2023. As per the brief, actually the attorney nor the recipient, appellant, had received a copy of that journal entry, whereas I went to the clerk of court's office and received a copy of it through the file. I believe this was sent by regular mail. I will tell that I have not received a copy of that to this day.
Counsel, with the e-filing now, would there have been a notification that a journal entry is filed on the docket?
No, domestic relations here does no e-filing.
Okay, so
Juvenile does on occasion, but that's elective by them,
okay.
but domestic clearly no.
Okay, so they're not up to speed on that yet.
No, they're not, unfortunately, and that's been something I think they're trying to adopt, and I know the judges and myself and various other attorneys have discussed that with them, that there's often a delay with the clerk or downstairs getting mail out,
Okay.
and regular mail is sort of unreliable, unfortunately. So, at any rate, an objection was filed to the magistrate's decision with a twofold objection, one of which was leave to plead, in the sense of it was 2 days late. It was about, I think, the 17th day. So I had asked the court to leave to plead it and supplement the transcript after the court had decided whether or not that leave would be granted. Now, according to my brief and according to what I would do is, obviously, if the court denied my leave, I would then be able to take that to the Court of Appeals and say it was improper that they would deny the leave. Had they granted the leave, the transcript would have been supplemented, then the court would have proceeded to hear the case on the merits, and then obviously it could either agree with the decision or not at that point in time. Now,
In your motion for a leave to plead, did you submit any affidavit or anything that said that you had not received a copy of the?
no, I did not, Your Honor. I mean, I know that I remember being on the bench, and attorneys are always under oath to, I would think, tell the truth, be subject to other civil penalties. So I did not have an affidavit of myself saying I did not receive that. However, when that went through, at some point in time, I know there was an objection filed to that by other counsel for various reasons, one of which was service, one of which was failure to provide a transcript, etc. Now, the reason the transcript wasn't filed, quite frankly, was really a practical matter. If the court did not grant a leave to hear this objection, then the transcript is not needed, and quite frankly, I'm not so sure the client could afford that. So we would ask, okay, at that point in time, all right, now we're going forward, we would require that transcript. At some point in time, I know that my opponent had indicated that the service wasn't timely, or service was not proper through the procedures. I will indicate, in Lorain County, I've never seen it any other way. If it was improper, she certainly entered a notice of appearance at some point and answered to it, so I don't think she can claim she didn't receive it. And if it was improper, I mean, I would ask that that timestamp still is timestamped, it would be sent back for service. I think that that would be the remedy in that case, if that's the way the court would decide that case. The fact of the matter is, I'm really arguing one point. The court, and unfortunately I've seen this numerous times with many courts, Some courts are fantastic about it. You have the right to cure the record, will be dismissed within this amount of days if you don't do it. Unfortunately, a lot of courts don't. So in this case, I received an entry after the brief of appellee was filed at the lower level, at some point in time later, saying it was dismissed because there was no transcript filed. Now, I believe the civil rules require, and specifically 41, that the court give an opportunity to cure any defect if it determines to a defect. And I think it's much like this court does. You have this many days to answer this. If you don't, this case will be dismissed. The transcript would not be needed. First, the lead was to actually proceed. If they were allowed to proceed, the transcript would definitely be filed. If it wasn't, it would be a proper dismissal. But in this case, the court did not give any opportunity to cure. I know that the appellee will argue at 59 days, but with all due respect, an attorney is not the court. So they can't say, well, I told you about it. The fact is I know a transcript has to be filed, but what good is a transcript without actually having the court rule in the first motion? Now, you could also argue, well, why didn't you respond to their motion? But that's not a requirement under the rules. So I was obviously waiting for a hearing date, which was not, in fact, given. And even if I needed to secure a hearing date to determine at the first instance when it's filed, once again, you still have a right to cure that. You cannot, as a lower court, just dismiss a case summarily unless it's on jurisdictional grounds without hearing, because then it would be avoided.
But the court didn't dismiss the case, they just dismissed the right to file objections, right? They didn't grant the right to file objections.
Correct. And according to the rules, if you don't file the objection, I can't raise it on appeal.
Right.
So then in essence, that's as good as a dismissal as far as I'm concerned, by practicality. So I believe this matter based upon the rules, and I think it's an important case, and I'm glad we're hearing it, because I think it will kind of settle some things about service, number one, and number two, about whether a court can just dismiss a case without hearing or giving a right to cure. I think it needs to be remanded. The court needs to decide whether or not it's going to allow me leave to plead that. If they determine there's no leave to plead, I'm not granting it to you, you're 2 days late, I have to come back here. If they do allow it, then once again I can proceed with the transcript, and if the decision was not liked by either party, we could proceed back up here again. I believe, as indicated, there are a lot of little nuances about this. I know the appellee brings up a lot of those, but still that the answer to all of this is, should a case be heard on the merits, the question is, and should there be a leave to do that and to correct the record? Not asking anything major, just simply the 2-day delay caused a lot of problems in this case, admittedly. However, I believe the lower court should have set a hearing date if it was going to dismiss it, or say it would be dismissed on this date if these things are not cured. For that reason, I believe the case should be reversed and remanded consistent with that. Thank you.
Thank you, counsel. You'll have your full 5 minutes on rebuttal.
Good afternoon, Your Honors. May it please the court. My name is Haley Martinelli, and I'm here on behalf of appellee Jennifer Traven. As the court is aware, the parties were divorced and are now former spouses, but for ease of listening today, I will refer to appellant as husband and appellee as wife. We're here today because husband failed to take the appropriate action at the trial court level and now seeks a second chance from this court. The facts relevant to husband's assignment of error are procedural in nature and are set forth largely in wife's brief, but in summary, husband filed broad and unspecific objections to the magistrate's decision, and in doing so failed to comply with several local and civil rules. Wife therefore filed a motion to dismiss husband's objection. Husband never filed an opposition to wife's motion, nor did he take any further action to ensure that his objection would comply with the civil rules.
Counsel, when he filed his objection, appellant, whether we call it objection or a leave to plead, what did the actual pleading say?
So, Your Honor, to clarify, it was objections to the magistrate's decision, and in the caption, it said leave to plead. There was no motion for extension of time filed, and there was no motion for a leave to plead filed. So there was nothing for the trial court to rule upon. There was no motion asking for an extension of time. There was no motion asking for leave. He included it in a parentheses in the caption of his objections, but nowhere was there any motion for the court to rule upon.
Okay, but in the body, what was in the body of the?
In the body of the, in the pleading was an objection stating that, as counsel stated, that he hadn't received the objection time, or the magistrate's decision timely, asking for leave, and a approximately 4-line, very broad objection to the magistrate's decision.
Okay, you just said he asked for leave.
Correct.
In the body?
In the body,
How
correct.
is that not a motion for an extension?
There was no separate, it was,
Does there have to be? I mean, why can't you just say
Well-
in the body, I want an extension?
well, Your Honor, and even if that is considered requesting leave to plead, regardless, there's nothing exempting husband from continuing to follow the requirements set forth in local and civil rules. There was nothing requiring him to wait for permission from the court to submit the transcript, to even make a deposit for the request for the transcript. Those are still things that husband has to comply with.
He only has to comply with them if his objections are timely and accepted.
Well, correct, but there's no exception in the civil rules or the case law that allows him an exemption because he's requested a leave.
Right, but he was already untimely.
Correct. So, Your Honors, 39 days after White filed her motion to dismiss and 59 days after her husband filed his objections, the trial court dismissed husband's objections and adopted the magistrate's decision. Husband's assignment of error is based upon his assertion that the objections were dismissed for failure to prosecute under Civil Rule 41B1. And at the outset, Civil Rule 41B1 is not the rule that's applicable to the dismissal of husband's objections. Civil Rule 53 governs magistrate's decisions, and specifically objections to magistrate's decisions. In dismissing husband's objections, the trial court adopted the magistrate's decision, which is one of the permissible actions under Civil Rule 53 D4B. However, even if husband were correct in applying Civil Rule 41B1, the trial court still did not abuse its discretion in dismissing his objections. So in responding to husband's assignment of error under Civil Rule 41B1, that assignment of error should be overruled because husband, 1, had notice that his objections could be dismissed, and 2, had ample opportunity to respond to the possible dismissal and cure any defects.
Counsel, I'm looking at the judge's order now, and it appears as if the judge didn't realize, and obviously, well, I'll look at the full docket, the full record, but it appears as though the judge did not either realize or just didn't rule on his request for additional time to file objections. She just indicated that filed an objection and has not found anything further, nor has he set his motion for a hearing. And no transcript was filed. It doesn't say that the request to file the objections untimely is granted. Or there was good cause shown or no good cause shown. It just doesn't address it.
Well, I think, Your Honor, because in the interim, between the time that the objections were filed and the time that that judgment entry was issued that you're referring to, no additional steps were taken. There was no response to wife's motion to dismiss the objections. There was no request for a transcript so that a supplemental objections could be provided. There was not a precipice filed to the court reporter to prepare the transcript. There was not even service to wife's counsel of the objections. So there were just multiple civil and local rules that weren't complied with within that time. that the court dismiss the objections on that basis.
What does it mean in the vernacular of this trial court has not set his motion for a hearing? That gave me pause.
Sure. So local rule, the Lorain County Domestic Relations Rule, local rule 9, C3 states that the party first filing objections shall obtain a hearing date on their objections. That's a unique feature of Lorain County Domestic Relations Court, that they require a party filing objections to obtain a hearing date on their objections. And that was again another rule that was not complied with when husband filed his objections. And one
Could he
thing,
have obtained a hearing date if he's had untimely objections?
yes, he could have obtained a hearing date, Your Honor.
Where does it say that in the rule?
That's not specifically in the rule, but the procedure for the court would have been that he would have called the court instead of filing objections. That's done through the assignment commissioners, and they would have given him a hearing date and put it on the schedule.
So the rule doesn't require there to be timely, because a lot of the rules will say upon filing of timely objections.
No, it simply says the party first filing objections shall obtain a hearing date on their objections. A copy of all objections or responses shall be served upon all other parties.
Thank you.
And a very important point, I think, to point out, Your Honors, is that husband repeatedly states throughout his brief that his objections were dismissed sua sponte, and that's just simply not true. As evidenced by the record, wife filed a motion to dismiss, and then his objections were dismissed. They were not dismissed sua sponte, as he continually contends, and husband intentionally omitted the fact that wife filed a motion to dismiss. This critical filing that speaks directly to his assignment of error was not even included in his brief at all. The record is clear that the trial court didn't dismiss husband's objections on its own with no motion. It did so pursuant to wife's motion to dismiss. And to husband's assignment of error, 41B1 requires first that husband have notice. And to my first point, wife's motion gave husband that notice. Husband's sole assignment of error seems to be that the trial court erred in dismissing his objections because he was not given notice of the possibility of that dismissal. But husband has failed to cite any authority which would support that wife's filing of a motion to dismiss did not give him the requisite notice that his objections could be dismissed. In fact, the case law cited by husband supports quite the opposite. Husband relies on Svoboda versus Brunswick in his brief. However, Svoboda directly contradicts husband's argument. In Svoboda, the Supreme Court of Ohio specifically quoted a staff note to Civil Rule 41B1, which stated, the rule makes clear that a motion, either by defendant or by the court, is the proper procedural device for implementing the dismissal. And the Supreme Court goes on to distinguish that in Svoboda, there was no motion to dismiss filed, and therefore the trial court did not have the authority to dismiss the action. Here, there was a motion to dismiss filed. Aside from the clear notice provided by the filing of wife's motion, the plain language of the local rule also gave husband notice that his objections could be dismissed. Lorain County Domestic Relations Local Rule 9C4 states, if a deposit for costs of a transcript is not made within 7 days of the filing of the objection may be dismissed. In the 59 days that passed between the time that husband filed his objections and the time that the trial court dismissed his objections, husband never made a deposit for costs of the transcripts. Between the plain language and the local rule, it's clear the husband had notice of the possibility of his objections being dismissed. And to the second point, not only did husband have notice, but he had ample opportunity to respond to the motion and explain any deficits, or take any action to correct them. 39 days passed after wife's motion to dismiss was filed until the trial court issued its judgment. In that time, husband did nothing. Husband also had ample time to take any action to comply with the local and civil rules. Yet 59 days elapsed between the time that he filed his non-compliant objections and the time that the trial court dismissed them, and in that time, husband took no action. And it was not only one mistake or omission in those objections. that he could have taken any action to fix. It was at least 6 rules that he disregarded and continued to disregard for nearly 2 months. He never served his objections upon wife's counsel, as required by Civil Rule 5 and Local Rule 9C3. He never set his objections for hearing, as required by Local Rule 9C3. He never filed a precipice for preparation of the transcript, as required by Local Rule 9C4. He never made a deposit for costs of the transcript, as required by Local Rule 9C4. He never supported his objections with the filing of the transcript, as required by Civil Rule 53, D3B3. And he never stated the grounds of his objections with specificity and particularity, as required by Civil Rule 53, D3B2, and Local Rule 9C2. Husband is required to follow these rules just like every other litigant that appears in the trial court. But within appeal as husband's second attempt, after he willfully disregarded the rules of the court at the trial court level, failed to respond to wife's motion, and failed to take any action for nearly 2 months, the trial court did not abuse its discretion in then dismissing husband's objections. And it should be noted that husband continued to disregard court rules in the within case when he failed to serve as appellate filings upon wife's counsel, which led to the motion to dismiss that was filed in this case. The lack of service by husband was prevalent throughout the trial court proceedings, continued through the objections, and now continues in this case. Husband continues to disregard basic rules of civil procedure even here in this appeal.
Tell me again what was wrong with the service?
In regards to the objections, Your Honor?
No, in regard to opposing counsel.
I'm sorry.
You said that the wife wasn't served.
Yes, correct.
And I'm looking at the motion and it says this certify a copy of the notice of objections has been served upon counsel.
Yes, there were, husband's counsel did always include a proof of service that he signed, but those were false. Wife did not receive them. Wife's counsel did not receive them.
Well,
I'm not sure what document you're referring to, so I don't.
Well, I'm looking right at the objection to magistrate's decision leave to plead requested.
Mm-hmm.
And at the bottom of it, it says proof of service. This is certified a copy of the foregoing notice of objections has been served upon counsel for the plaintiff by a regular U.S. mail.
Yes, that is what it says, but that is not accurate.
And how do you know that? And how do you have any record of that? And was there any record presented of that?
I mean, the record presented is that wife filed a motion to dismiss. I filed a motion to dismiss stating that I was wife's counsel, me was never served. I have no record. I can't provide any proof of something that I did not get. So
Does the case law say if there's a proof of service, it's presumed? So you would have to make that burden, you would have to reach your burden to show that he didn't actually serve you.
again, Your Honor, that was one of many
I'm
issues.
just trying to get it all straight.
Sure.
Thank you.
And my point, Your Honor, was that this was something that was repeatedly an issue throughout the trial court level and now here again in the appeal. And you're correct in that I can't prove that I never received anything other than, a search of my email history and my office's email history.
Counsel, I'm gonna need for you to conclude, because you're
Sure.
out of time.
Sure, thank you. So, in conclusion, the trial court did not abuse its discretion in dismissing husband's objections and adopting the magistrate's decision. And I thank you all for your time and respectfully request that you affirm the judgment of the trial court. Thank you.
Thank you, counsel. Counsel, you have your full 5 minutes.
Thank you. I will note that, looking at a copy of my objection to the trial court, I believe that it does comply with the rules. First of all, I sent by regular mail to opposing counsel. Certainly, to make the accusation that in some way I'm lying, I think is a pretty big stretch.
Well, I gave her a hard time, so I'm going to give you a hard time too.
Yeah.
Your brief, you keep saying this is sua sponte dismissed. How's it sua sponte dismissed whenever they filed a motion to dismiss?
Well, you're
Or
correct.
did it upon motion?
You're correct there. That was a misstatement, this is sua sponte. However, I was under no obligation to answer that dismissal, nor was it, in essence, I'm asking for leave to plead. So if you look at my objections, the first objection to magistrate's decision, the first whole part of it, before getting into sections 1, 2, 3, and 4, indicate that there's 2 days beyond time. I admitted to that. I'm asking that my objections be in fact permitted to amend and supplement this objection upon receipt of the transcript of the hearing. And I asked the court to give me leave to plead that, and I do that throughout the record. Or my actual motion, that is, I'm sorry. Now, I will indicate with specificity, not that I don't believe this hinges on that as well, but I did put the magistrate erred to use discretion in entering a decision finding spousal support is warranted in a 2-year marriage, so that was specific. Didn't have anything to do with the amount of money each party made. It was a 2-year marriage. I indicated that awarding the plaintiff an award which amounted, I believe, to compensatory damages, and that would have been on the record because there was an alleged assault. And I indicated that that evidence should not come in for damages because that assault was not proven. And thirdly, the factors weren't followed by spousal support and did not rely upon the facts. So certainly, I believe that's specific enough. It's not, the specificity isn't when the plaintiff said X, Y, and Z or defendant said X, Y, and Z. But that certainly would have been cleaned up with the supplement as soon as the transcript was there. So the question really becomes is whether the court, I think, had to indicate that, hey, if you don't do X, Y, and Z, we will clean up this order, or we will dismiss this. I think it's important to know, we talked about local rules quite a bit. Did you know in the local rules, if you follow that logic, even her objection or her motion for dismissal should have been set for oral hearing? It was not. So it's certainly, it's calling the kettle black there, because that wasn't as well. I did put, as you notice on my objection, a time for a hearing, didn't have a time for a hearing. Certainly if it was that important, I guess the clerk could have called me for a time for a hearing. It says it will be set, things of that nature. I think what the rule actually states, and I didn't anticipate this coming up, is that all motions will first be set for pre-trial hearing before a magistrate, etc. So it doesn't automatically go straight to hearing. The motions are set for pre-trials and times are established. This is not a complicated case in the sense that just, my guy's not getting a second bite, just wants one bite. And it was a 2-day late filing, filed it on the weekend by fax because it's the only way I wanted to make sure it got there as quickly as possible. And we were asking that this case be remanded for the judge to determine whether or not the leave to plead is granted and whether the 2-day filing late is warranted and whether it's in their discretion it should be dismissed or not. There's a chance the judge may say, I'm sorry, it's dismissed. Then I'm right back here. But I'm here on a little slightly different grounds. All I'm asking is for the judge to decide that, which she never decided to leave the plead to begin with. So I'm asking that this case be remanded in that regard. Thank you.
Thank you, counsel. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day it is released, and the opinions will also be posted on the Ohio Supreme Court website.
Thank you.
Thank you both again.
Thank you.